The learned counsel submitted that the judgments relied upon by the respondent in Amritsar Gas Agency, Rajasthan Breweries Limited, Royal Orchid, etc., are not applicable to the facts and circumstances of the case. Alternatively, learned counsel, without prejudice by not admitting that the locked-in period had expired, stated that to invoke Article 35 2A even after the expiry of the lock-in period of 5 years on the ground of shortfall of financial performance for 3 consecutive years, the same must be for 3 consecutive years relating to the period after the expiry of the lock-in period and not prior to it. That apart, he stated that even the physical possession of the hotel is with the petitioner. In this regard, he has referred to Article Section 4, which gives operator a right to lease, sublease or grant concession, etc. Article 5, 9 and 10 provides that operator would operate without any hindrance and owner will not interfere in the day-to-day operations. He also referred to Article 6F, which provides that even for inspections, owner has to give a prior 3 days written notice. He also refers to Article 19(2)(b) to contend that the owner gave an undertaking that the property was not mortgaged or charged to adversely affect the rights of the operator. He also states that Article 23 clearly provides that the operator has to be compensated before vacation of the premises by the operator, and Article 25 subclause 2A, 3 and 5 provides the right to recover projected 3 years fees or interest before vacation of the premises. He states the agreement creates an interest in favor of the petitioner in the hotel and the petitioner has an indefeasible lien and charge over the hotel and to preserve and protect his possession thereof as contemplated by Section 202, read with Section 221 of the Indian Contract Act 1872. The respondent can only seek possession of the hotel from the petitioner consistent with the settled jurisprudence which mandates by virtue of various of decisions of Supreme Court by taking recourse to due process of law and not illegally or forcibly. In this regard, he has relied upon the judgments in the cases of Kavita Sayan and others versus Balsara Hygiene Products Limited and Southern Roadways Limited, Madurai, represented by its secretary versus S.M. Krishnan SC3. A reply to the petition has been filed by the respondent, Mr. Gaurav Sharma, learned senior counsel appearing for the respondent would submit that the petitioner carries on the business of operating hotels in India and the respondent is a hotelier in the city of Dehradun, Uttarakhand, who owns the hotel. On May 15, 2015, the petitioner and respondent entered into an agreement for the operation of the respondent's hotel at Nanda Ki Chowki, Chakrata Road, Dehradun, Uttarakhand, called Viganta LP Villas. The agreement is a commercial agreement in the nature of an agency which allows the petitioner to operate and manage the hotel of the respondent as an agent of the respondent in consideration of management fees. The commercial operation of the hotel started in July 2017. However, the petitioner repeatedly non-performed and failed to meet his own targets, posing losses to the respondent. The petitioner breached its obligations under the agreement, including but not limited to its obligations under Article 25 2A of the agreement. According to Article 25 2A, in case of underperformance of the petitioner by more than 15% from the projected gross operating profit for consecutive 3 years, the respondent has a right to terminate the agreement without any penalty. It is the case of the respondent that the petitioner has underperformed by more than 15% from the projected GOP for consecutive 3 years. That is, accordingly, the respondent exercised its rights under the agreement and issued a notice on July 28, 2020 to the petitioner seeking to terminate the agreement on expiry of 60 days. The petitioner did not respond to the notice. It did not make any attempt to amicably resolve the matter between the parties. Instead, the petitioner filed the present petition seeking protection from this court against termination of the agreement. Learned counsel submitted that the petitioner in its petition has not disputed the underperformance on its part as the reason for issuing the notice. According to him, on September 8, 2020, the petitioner had issued two letters through email to the respondent informing that its current general manager has resigned September 30, 2020, which has been accepted by the petitioner. The petitioner, through another letter, has informed the respondent that it has appointed a new general manager for the hotel, who will reach the hotel on September 25, 2020. Learned counsel submitted while the respondent does not accept the petitioner's position as set forth in these letters. The respondent has not responded to these letters at this stage in view of the court's order. Stop.